Hi, my name's Tom King, and I'm the founder of Toolkit.law. We're here with two great attorneys. We're here with Zainab Elkadiri and Ann Kennedy, both attorneys in the United States. Our topic is ADR or Alternative Dispute Resolution, specifically international hearing considerations. They put together this help sheet. Follow along. Zainab, I believe you did the green column, correct?
That's correct, Tom.
So, what do you want us to know about pleadings and foreign orders regarding international hearing considerations for ADR?
So I took the pleadings and foreign orders and divided it into a few subtopics, starting with jurisdiction. Jurisdiction is established through the consent of the parties, the connection to the dispute, like the location of the dispute or where the parties are domiciled, and relevant international treaties such as the Hague Convention. Foreign pleadings must meet court rules, be accurately translated, and will likely require certification. Foreign orders must be certified. Principal courts often consider when determining whether jurisdiction would be proper include conflicts of law, comity, and the universal jurisdiction rules. Recognition of foreign orders. So the United States is actually not a signatory to any convention or treaty that requires recognition or enforcement of foreign court judgments.
Ah, okay. I didn't know that. Go ahead.
Right. However, foreign judgments are routinely recognized primarily on a state-by-state basis. U.S. courts will determine whether the original court had proper jurisdiction, confirm due process was followed, and may decline enforcement if the judgment violates the foreign state's public policy rules.
And of course, that's not just important from an American perspective, but there's somebody at the other end of those orders, right?
That's correct.
Right. So
Absolutely.
if you're from a different country, you want to make sure that you know how to get it in, or if you're here, you want to make sure you know how to get it out. Okay, that's cool. The other thing I learned recently in recording another one of these presentations, that you even have to agree on what laws the orders will be done in, what language the proceedings will be done in versus what language the work product will be done in before. I thought that was very interesting.
That is interesting. International treaties like the Hague Convention can simplify the recognition and enforcement rules between the participating countries, which can save a lot of time and heartache. Regarding translation of documents for an international hearing involves selecting qualified translators, submitting documents for translation, and ensuring accuracy. Translations are often required to be certified for authenticity and accuracy with a certificate provided by the translator. The translated documents are then submitted to the court following that court's specific rules and that court's specific procedures. And some international courts may handle transactions directly through their own teams. And then we move into service of process. Service is typically accomplished through direct delivery to the party or their legal representative via courier, registered mail, or personal service. And it can also be done through diplomatic channels or by specialized international courts and organizations, depending upon the case and the jurisdiction. And service often follows international conventions, such as the Hague Service Convention for serving documents abroad.
Lastly, I see you have something on filing requirements.
That's correct. It is vital to familiarize oneself with the filing requirements and adapt foreign pleadings to align with the international court's rules. So this includes ensuring pleadings are translated, certified, accurate, and submitted before the required deadlines and served on all relevant parties. Depending on the court's pleadings, it may need to be filed electronically or physically. I'm sorry. Yeah. Depending on the court, the pleadings may need to be filed electronically or physically, and they must comply with specific content and structural guidelines.
Fantastic. Now I see that column was called pleadings and foreign orders. And as we continue, you had some thoughts regarding parties and witnesses in ADR proceedings. Go ahead.
Did basically, one of the things to give an overview, or that's fundamental to an international arbitration is that it has to be done by agreement, right? So if you're going to be a party you're not going to be a party to an international arbitration agreement without an agreement to be a party to that, right? So, so really in an overview, the first question I always have is, well, why are people willing to do this, right? But believe it or not, certainly in a commercial arbitration context, or sorry, in a commercial dispute context, arbitration is the preferred, dispute resolution. And of course, there are some advantages to that. As I've laid out here, there's an advantage because if you have an intra-country or an international dispute, arbitration offers a means to be able to have a neutral forum. The parties have the ability to choose their panel who's going to be an arbiter. They can essentially pick their judge, right? There is procedural flexibility, and then there's confidentiality. Now, one of the things, Tom, that's really kind of interesting, or if you will note, is I did not say it is cost effective, because very often there is a huge cost associated with an arbitration hearing at the point in time that you get to a hearing stage. You will end up having fact witnesses and also expert witnesses. And expert witnesses can really make or break your case in an arbitration. But if you look at I guess to kind of start back at the top, a fact witness is a witness that has direct personal knowledge of relevant facts in a case. When you have an international arbitration hearing, the hearing itself comes at the end of the case where it takes the place of a trial. I mean, what we would think of certainly in America or in a common law system as a trial. But, the parties generally will give an open statement. Fact witnesses and expert witnesses will both be presented. They'll be examined and cross-examined by the parties. However, one thing that's different in an arbitration setting than you would normally find in a litigation setting is that the parties will end up having tendered their experts or disclosed very detailed statements in support, both from the fact witnesses and the expert witnesses in the case, prior to, well in advance of a hearing in arbitration.
What's the next box we're going to focus on?
All right. So the next box, I think, is, let me just to go through the highlights basically on who can be a party, right? I mean, one of the benefits to an international arbitration is that you've got a lot of diversity that you can meet. I mean, you can have individuals, you can have different countries, the countries themselves, or agencies. One of the reasons that international arbitration is favored and ultimately having a hearing to resolve the dispute, it's favored by sophisticated or even, I mean, there's a wide variety. You can have everyone who's from an individual to a multinational company participating in the process and then being able to select their judge. So I'd like to go ahead and go to the expert witnesses. One of the things that I thought, or that I think is interesting about international arbitration is, number one, it can be a complete free-for-all. So whatever rules the parties want to use, the parties are pretty much free to do so. Now, with that said, there are several governing bodies and major bodies that have promulgated rules and pattern rules. But, in general, if the parties want to shorten things up or streamline, Tom, you mentioned previously with Zainab's presentation that you were surprised to hear that sometimes the orders would be in different languages in the proceedings, and I'm not. If you actually look at, one of the things that's unique about this process is that sometimes the parties, I mean, you truly can have an international and global forum, right? You might have parties that are from two different nationalities. You may have the proceedings themselves being held in a country where then the rules that apply arise out of another country. So it's a very interesting area of the law.
Anything else in this column we need to cover?
No, I think not on the general hearings, other than, I mean, on the general parties and witnesses, other than I do think one thing that is interesting is when it comes to expert witnesses, right? I mean, expert witnesses, as most legal practitioners are familiar with, they're experts, right? They're guys who have specialized technical knowledge, they're gap fillers. One of the nice things about arbitration is that sometimes you can pick to have on an arbiter a technical expert, right? Or somebody who has that expertise. If you're having a serious dispute in the oil and gas world and you need somebody with some trade sophistication, I do think that that is good. And then there's a cool term that I learned here called hot tubbing, right? Or that I would like to share with you guys. And that is
Holy
basically
moly,
where
Ian, where are you about to take us? My goodness.
I know. We're gonna have
Oh,
some
my
hot
stars.
tubbing. There's hot tubbing that goes on in international arbitration hearings, but what happens is essentially you have two experts to shorten things up. It is very common for competing experts to have, rather than individual question and answer sessions, they basically are mixed together and it becomes an organic discussion where, you know, they can disagree with the other experts' findings or try and come to a centralized theory to apply to the case. And so they call it hot tubbing. So that's just, I'll leave us on that for what to know about the parties and the witnesses.
Yeah, for a moment I thought I was going to have to charge more for my CLE.
No.
Okay. Now let's go ahead and go to the backside of the help sheet that the two of you did. Zainab, let's go ahead. Now, I believe you have evidence and exhibit considerations. Is that correct?
That's correct, Tom.
Please go ahead.
My next area is going to focus on evidence and exhibits, and my first section is on admissibility standards. So the admissibility of foreign evidence is assessed based on its relevance, authenticity, and compliance with international treaties and conventions. Evidence must meet the legal standards of the respective court, ensuring it is reliable and obtained fairly. So you definitely want to dig deeper and find out what the legal standards are of the respective court you're looking at. Then we talk about authentication of evidence. The authentication of evidence in international hearings, that requires thorough verification via methods such as certification by the issuing authority, apostille or consular certification for foreign documents. Witness testimony may also be used to confirm accuracy. Maintaining a clear chain of custody, which is super important. It's crucial for validating authenticity. International courts have specific rules for evidence authentication, and cross-border cooperation may be necessary to confirm the legitimacy of the evidence. Regarding translation of evidence, which we touched on a little earlier, but accurate translation of evidence in international hearings is essential for clarity and fairness. As you can imagine, with all the different international bodies that are involved in court, there's a lot of different language barriers, and translation is regularly required. It must be done by qualified translators. It must be precise and complete and meet the court's specific rules and timelines. Translated documents may require certification, notarization, or consular authentication and must be in the court's official language or languages to ensure fairness and legal validity. Touching again on the chain of custody, a clear chain of custody is essential to maintain the integrity, authenticity, and reliability of the evidence being produced. That involves documenting every transfer and handling of evidence and complying with international legal standards. This protocol, it strengthens the likelihood of the evidence admissibility in court and helps to prevent challenges to its authenticity. International cooperation, detailed tracking, and witness testimony may be required to confirm the chain of custody. And lastly, I'm going to touch on expert witnesses and legal privilege. Expert witnesses help contextualize foreign evidence by explaining technical, legal, cultural, or linguistic aspects that may be unfamiliar to the court, kind of like what Anne touched on earlier. They can provide context, evaluate evidence, and support arguments. Determining if evidence is protected by legal privilege is an international court. In an international court, it varies greatly between the jurisdictions. So the International Bar Association rules serve as a reference point for privilege issues. Protective measures such as redactions to safeguard sensitive information are often used.
So I want to point out that the column we're in right now is regarding evidence and exhibits, and that's how you touched on expert witnesses. And in the previous page, we were talking, well, parties and witnesses, a little bit of an overlap. Absolutely. Okay. And you have the last column, foreign venue considerations regarding international arbitrations. Go ahead.
So this is to build on what I was talking about earlier. I actually want to drop us down. I've structured foreign venues, but ultimately, to give a bird's eye view of things, one of the biggest issues is going to be, hey, where should we have a forum for our arbitration, right? Or for an international arbitration. And there are some very strong practical and logistical considerations, right? The first is, generally speaking, it's a good idea, looking at the top on an overview, to select a place that is reliably neutral, right? There, in my world, for example, if I have an international child custody dispute, I may want to ask to find a legal framework or a location that is neutral, that neither parent is affiliated with, right? Conversely, sometimes I will want to see whether there can be an international arbitration where one side or the other does have a country tied to it, because enforceability is going to be something that's a consideration. Attention needs to be paid. I'm up on the international arbitration hearings in the overview. Attention needs to be paid to whether a foreign venue offers arbiters with a good reputation. And this is very important. Often arbitration can be a significant expense. So knowing whether there are panel arbitrators that are available that can service the issues that are in the case is something that goes into where we're going to have this thing. The next thing that I probably would like to focus on would be something that I thought was I touched on earlier, but under the heading International Arbitration Hearings Legal Framework, that's where I am on the help sheet for reference. The seat of an arbitration, to use some arbitration jargon, the seat of the arbitration is the is the legal place that it occurs, right? That's the legal framework within which it takes place. But the physical location of the hearing, that can be somewhere else entirely, right? So traditionally, we've got some cities across the world that are very arbitration friendly. London, New York, Paris, Hong Kong, and Singapore, right? So each of those places have a lot of freedoms and a lot of robust services. You can really find good translation services there. And so that is something to consider, where the legal framework may come into context, right? But, and this kind of goes down into the next section being enforceability, right? So where you have the legal framework that the proceedings are conducted in, that's critical to whether you can enforce an award. And ultimately, a practitioner really wants to give strong focus to whether an arbitration award can in fact be enforced. There is a convention, it's a multi-country convention called the New York Treaty, called the New York Convention, that basically allows a reciprocity in enforcing judgments. And this is incredibly beneficial when you have a sophisticated commercial dispute in the oil and gas industry, for example, right? Another area that can be greatly impacted is in computers, right? Computers and digital and tech, arenas can be, disputes can benefit from having the reciprocity for enforceability. And then there are some practical considerations to keep in mind as well. You know, I've mentioned a couple times that a cost is not always saved over an arbitration than with litigation, but the ease of accommodating witnesses. You know, you could agree to have the procedural rules conducted under British law, but we're going to have Singapore, and we're going to allow everybody to appear by Zoom, and we're going to allow them to appear, you know, 2 or 3 days. I mean, there's a lot of flexibility that goes on in an international arbitration hearing as opposed to a courtroom.
Any other considerations you want to touch on in that box?
I think on that box, I mean, you know, the practical considerations would just be, I mean, we talked about translation and the accommodation of witnesses, but that's, I mean, no, it's pretty, yeah, just keep in mind the logistics of things.
Let's talk a little bit about something. Certainly, you know, the finish line is the arbitration award, right?
Yes.
Do the two of you have any thoughts on considerations regarding the arbitration awards?
So I'll jump in and say on there, I mean, the answer is yes, right? That's sort of what goes back to where you want to have had it, what rules you want to play by, the enforceability. I mean, a practitioner really, or at least I would be mindful of having the arbitration proceedings conducted pursuant to recognized rules and procedures in a place with a legal framework that's known and also very open. I mean, the United States is a very easily, I guess, very receptive and welcoming of enforcing an arbitration award. I mean, that is the purpose of the New York Convention. So I would 100% emphasize that.
Any other thoughts, Zainab, that we left out that you want to touch on?
Not that I can think of. I think Anne was particularly thorough on the international arbitration hearings and all the different considerations. And I tried to really stick with all the things that come with a trial and jurisdiction, exhibits, pleadings. So I hope this gave a good, well-rounded, just bird's eye view of the process. So I don't think I have anything else at this point.
Yeah, and of course you want to pick good arbitrator. You want to pick a good panel, right?
Right. Absolutely.
The one arbitration that I experienced, I only found out afterwards that the arbitrator was wearing a Rolex watch that the opposing attorney had given him.
Oh my goodness.
Oh, wow.
I will say,
And just forgot to disclose that.
Oh my.
I will say that I have seen panels that have non-lawyers on them, which is nice. It's really nice. I mean, sometimes there will be a need for that technical expertise. So there's a lot of flexibility.
If it's engineering, right?
Yeah, absolutely.
If it's medical, right?
Yeah.
Okay, fantastic. So this concludes for our ADR section of the Toolkit.law CLE webinar. This has been our presentation on international hearing considerations with Zainab Elkadiri and Ann Kennedy, two experienced attorneys here in the United States. Go to Toolkit.law for more information. Thank you and goodbye.
Thank you, Tom.